Once the overview is completed, then there's the order of questioning. And this really depends on the individual judge, to be honest with you. That's why it's always good to know a little bit about the judge, maybe do a little bit of research, or if your representative has experience with the judge, that can become very valuable. Because different judges do things differently. What I mean by that is, I would say that the majority of the time, a hearing begins with the judge asking the claimant questions about their medical problems, their work history, and they'll ask the bulk of the questions for their own education about your case. Then the judge may turn it over to the attorney to follow up, or representative, or the claimant, if they're unrepresented, to give them an opportunity to present their case. And at that point in time, the representative or individual who's following up is really expected not to cover the same ground that the judge already covered, but to introduce anything that hasn't already been covered. The number of questions asked by that individual really depends on how much ground was covered by the judge. So therefore, if the judge covered an absolute ton of ground, say asked 1 hour's worth of questions and really covered almost everything, then that may not leave much room for the representative or the claimant to discuss. I mean, the judge may have really covered everything exhaustively. And if that's the case, then the attorney or claimant may only have just a few things to say, if anything at all. However, I've also seen cases where the judge only asks a few clarification questions, literally only 2 or 3 questions, and then asks the attorney to do the bulk of the questioning. In that instance, in that situation, the attorney may be asking a whole lot more questions than they might in another case. So again, the attorney could ask anywhere from 5 minutes of questions to an hour's worth of questions, just depending on what is justified by the case. But I always tell my clients, do not be frustrated if you feel like the attorney didn't ask a lot of questions, because that may simply be because the judge already covered a lot of ground. Once you, the claimant, are done testifying, either by having questions from the judge and or attorney, then the questions do typically move on to the vocational expert. Now, we'll go over the vocational expert in a later video, but keep in mind that the judge will ask what are called hypotheticals of the vocational expert, where they're asking them whether they think the individual can perform jobs, giving a certain set of facts that are given in the hypothetical. The judge may then turn it over to the attorney to ask their own hypotheticals. And again, the attorney may decide not to, because if some of the hypotheticals found that the claimant's not capable of working, then there may be no additional questions that need to be asked. Or the attorney may ask a hypothetical of their own, and that could be very important.